In late June, 8 defendants alleged to have been involved in a Palestine action break-in at an Elbit weapons site near Bristol stood trial at the Old Bailey in London. Ian Sanders, William Plastow, Alexandra Herbik, Tota Hocha, Hannah Davidson, Yulia Brigadirova and Madeline Norman were all charged with violent disorder and criminal damage in relation to that action, despite not having been present at the Elbit site when it happened. William Plastow was acquitted of the violent disorder charge during the trial. Today, though, the jury has returned no verdict on all the remaining charges against the 7, meaning it was unable to find them guilty of anything, of any of the charges. The prosecutor in the case had alleged that the 7, so sort of part of what's known as the Filton 25, helped plan the action. So they weren't there, but they're saying they were, well, the allegation was that they were involved, and that they compiled an equipment list, undertook reconnaissance, purchased items used by others and coordinated the break-in and its filming. All 7 had previously been charged with aggravated burglary as well, but were formally acquitted of that charge in February this year, after a jury cleared the 6 activists who actually broke into Elbit, or who were actually alleged to have broken into Elbit, I should say, of that charge during their first trial. Now, in this latest court case, all defendants denied any wrongdoing, and after 37 hours of deliberation, the jury was unable to find the 7 of them guilty of anything. So it means the case found it collapsed. There might be a retrial. We don't know. Now, according to the Filton Defence Committee, during that deliberation, this is the key bit, the jury also asked the court whether the defendants would be sentenced as terrorists if they returned a guilty verdict. Now, the judge, we understand, replied that it was a matter for him to consider and not for the jury to worry about. But the fact the jury thought that was a relevant question really is notable. So back in June, a judge sentenced 4 Palestine action activists who had been found guilty of criminal damage at the Filton site as terrorists. Now, that was after he found a terror connection in their offences. So the judge found that. But during that trial, the jury had not been informed that that could be a possibility. And reporting restrictions at the time meant it could not become public knowledge that defendants might be sentenced as terrorists if they returned a guilty verdict. Now, we speculated at the time that the jury might have felt more than a little deceived by that, right? So they thought they were finding these defendants guilty of criminal damage or whatever it was, but it turns out that what they had condemned those people to ultimately was terrorism, even though they didn't know at the time. So could it be that members of this particular jury read about that prior case and are now refusing to play ball? Stephen, you are our resident expert on Palestine action and actually all things legal. You're much better at this than me. You're better at the details. What's happened here? Is this the case that the jury have thought, we've seen in the past that you asked a jury to find if this person was guilty of criminal damage, and then afterwards, unbeknownst to us, you slapped on a terrorism element to it and they went to prison for much longer than we could have imagined?
I mean, I think that's potentially really, really likely. I mean, it was very widely reported after the guilty verdicts had been handed down in the original Filton case to the 4 of them of criminal damage, that the judge was going to consider a terror connection. And at that same time, reporting restrictions were lifted, which meant that it could be revealed that, that had been known about throughout the trial by the defendants, for example, but not by the jury. In fact, people weren't allowed to talk about it, either in public or in the court. And obviously, there's a connection between that case and this case. So that's plausible. But I think what I actually find interesting about the jury asking this question is that I think it indicates something very crucial to justice in this country, which is a breakdown of trust between juries and the judiciary. It's now the case that a jury understands that it's possible that in some cases they could be asked to find someone guilty of a particular ordinary criminal charge, only to find that what they've done is, through their decision, sentence them to much longer and much harsher terms in prison because, independently of that decision, the judge finds a terror connection. And, this is not something that nobody ever thought about. I mean, lots of times on this show, I've talked about a House of Lords debate that happened at the time that the law that involves terror connections for lesser crimes came in, which was around 2020, where this Liberal Democrat Lord was saying, we're going to have this situation if we apply this in this country where juries will just be deceived about what it is that they're doing when they think they are earnestly hearing a case which has a particular limited charge with a particular sentence attached to it. And so that's one consequence of what might happen here. There's another interesting consequence, I think, which is to do with something that I don't know if you've ever heard of this before. It's called Hoffman's bargain.
Oh, God, I've never heard of that before.
Okay, so in 2003, 5 people broke into the Fairford Air Force Base ahead of, shock and awe in the beginning of the Iraq War, where there were American B-52 jets. 2 of them broke in on one occasion, and they managed to slash fuel, pipes on fuel supply lines. They managed to break equipment and meters and dashboards and things like that. On another occasion, 2 people tried to get in, and they were caught. And then a fifth person tried to get in, and he was carrying petroleum mixed with very washing liquid and a box of matches because he planned to set the wheels of the B-52s on fire. Now, that case was a case of direct action where, at that point there was a lot of suspicion, not unfounded suspicion, that the war that Britain was about to undertake with the US was illegal. And so they tried to use as a defense that they were actually trying to stop an illegal war. Before they even got into the criminal courts, that was heard by appeals courts and eventually even got to the House of Lords, where one Keir Starmer represented one of those Fairford activists in trying to push through the idea that stopping an illegal war was a legitimate legal defense for the criminal damage. Now, the House of Lords decided it wasn't. There was a lot of political pressure at the time as well, because the Attorney General certainly did not want to release the legal advice he'd received over the Iraq War. So the House of Lords found that they couldn't use this defense.
Sorry to intervene. Yeah. So if anyone's, why was this going to the House of Lords? That's because the Supreme Court didn't yet exist.
It didn't exist.
And that used to be, the highest court used to be the House of Lords.
Quite right, exactly. I should have said that. So anyway, in the House of Lords, they declined to allow them to use this offence of the illegality of the Iraq War. And in the ruling that came out from the Lords who were involved, one of them, Lord Hoffman, sort of described what he took to be a kind of pact between direct actionists and the state, which was that, direct actionists, could display through, criminal damage or crimes, their conscience on the one hand, but on the other hand, the courts would be lenient on the condition that those people admitted what they'd done. They were open to the fact that what they had done it for these reasons of conscience, and they didn't, they weren't afraid of declaring that. And that is a kind of bargain that has sort of more or less stood, although it's been diminished of late, but it's now totally diminished. So in the Filton 4 trial, one of the things that the judge said there in his sentencing, once he'd found the terror connection, was that he held it against them that they hadn't admitted to what they'd done, that they hadn't just said, I admit to criminal damage. I mean, they admitted to all sorts of things, but they didn't admit to the charges. But of course, if you know that there's a terror connection hanging over your head, why would you admit to anything? Because you're not just admitting to the charge, just as the jury is not just finding you guilty of the charge, you're admitting to something much greater, that you are in some way not guilty of a terrorist crime, but connected to terrorism, which carries aggravating factors. And, why would anyone admit that? So that bargain is completely thrown completely out of the window in that case. So yes, 2 broken bargains, I think. One indicated by this question between jurors and the judiciary, and the other, a much more fundamental bargain around what the proper way to treat direct actionists is in this country.
And so this case ended with sort of no verdict, which presumably means the Crown Prosecution Service might try and have a retrial.
Yeah.
And I suppose, is there a way that they can sort of try and have a jury that doesn't know about all this terrorist connection stuff? Or is this, because this is a widely known news story, I don't think they can block someone because they've, read the Guardian, read the newspaper, or whatever.
Yeah.
So this could potentially make it very difficult to charge Palestine Action people, or at least get them convicted, because there'll be someone on the jury who says, I'm not quite sure about what's going on here.
We just don't know. And it's true, but, they just don't know. And I think that will make it more difficult. I mean, it seems like without a doubt.
The other thing that keeps sort of shocking me whenever I read it is, so these people, they haven't been found not guilty, or at least of all the charges. So there's been no verdict.
No verdict, yeah.
So they're not cleared yet. But they might be, and they've already spent a really long time in prison. So some of these people, they weren't there. They're charged with maybe having some involvement in the planning of this action, and they've been in prison for over 12 months. Many of them, although they're out now, aren't they? But they've spent a lot of time in prison.
Yeah, they were. So many of them were bailed when the first Filton 6 trial collapsed, when the aggravated burglary charge was when they were all formally acquitted of it. But yes, they spent, the 7 who the jury has found no verdict on today, spent between, I think, 15 and 18 months on remand in prison. And not just, and they were also all, arrested during dawn raids by counter-terrorist police. And, if you read some of the reporting on the trial, the charges put to some of them are that they cooked a meal for one of the people who broke into the Elbit site, or that they gave one of them who was acquitted a lift somewhere. It's really obviously I haven't been following the whole case. I've just been reading bits of the reporting today. There are other reasons why the jury, it seems, might have been doubtful about these charges.
Let's look at another. Well, it's not a court. This is a decision coming up, isn't it? Because on Friday, we will see a judge considering whether there is a terror connection in another Palestine action case. So 5 activists here were found guilty of criminal damage in July. And that was after causing an alleged £200,000 worth of damage to a Barclays bank branch in Burnley in August 2024, when they sprayed the storefront with red paint and splintered some windows. Now, I know lots of people looking at the damage think, was that really £220,000? But anyway, they've been found guilty of the criminal damage. However, in that case, the question of whether there was a terrorism connection was raised by the judge himself. Interestingly, unprompted by the prosecution. So sort of, the defendants were found guilty. The prosecution hadn't even mentioned it. And then the judge thinks, maybe there was also some terrorism going on here. That was, again, after the convictions were secured. So what's going on here? I mean, how big a difference would it make if, presumably these guys, I imagine they're already in custody, are they? These ones, if they've been found guilty? Or?
No, I think, I'm not sure. I think they're on bail.
They're on bail.
Pending sentencing.
How big a difference would it make here if the judge does decide there was a terrorist connection?
It's actually really impossible to say, because there are so many factors that go into sentencing and then go into the level of aggravation caused by terror connection if one is found. But there are some things that, certainly are true, that, if terror connection is found in your offence, then you're subject to monitoring for a really long time. Once you've finished your sentence, you're also having to report things like new relationships, new phone numbers, moving home for a serious period of time. If you're in custody, you're treated within the prison complex, the prison system, as someone who has a terror conviction, which means that you're treated very differently from the general population in lots of ways. It's a very significant thing to find. And I think one of the really interesting things about this is that, the Terror Act, when it talks about criminal damage in relation to, when it's defining terrorism, it's serious criminal damage. And the question here is whether, in the Filton 4 case, I think it was estimated around £1 million or something like that. In this case, we're talking about, a fifth of that. What counts as serious is...
I think we've talked about this before on the show, where there was a debate in the House of Commons when the Terrorism Act was first being passed, where there were MPs who had sort of objected to criminal damage being included as possible terrorism. And then I think whoever was speaking for the government said, look, we clearly can think of sort of scenarios where attacking property could be terrorism. Think about if they attacked the electricity infrastructure, for example, or poisoned the water supply. Yeah. So they were making the argument like, no, it is possible that you could have property damage that looks like terrorism, and that is true. But now they are
a shop front.
That's not terrorism.
Shop front with spray paint and splintered windows. That's and nobody imagines that is could possibly be an act of terrorism.
Yeah, and maybe now that is undermining these cases, because juries are thinking, well, I don't want to find them guilty of criminal damage if I think that they could end up then being called a terrorist, because it doesn't make any sense.
Yeah.
Brilliant, thank you for that update.
That's all right.
I'm always so enlightened when you come and tell me about the latest of these court cases.
I do my best.
I learn about Palestine action, I learn about how the legal system works, I love it.